Kevin Lewis of ABC 7, WJLA here in Washington, D.C., reporting on one Nestor Lopez Guzman. You just heard Maria Leaf give you some of the details. Molested two underage children, family members. He's 21 years old. He's a Salvadoran national. According to ICE, according to Kevin's reporting, ICE has told Kevin Lewis at ABC 7 that Lopez Guzman is in the country illegally. At least the sixth undocumented immigrant arrested in Montgomery County on rape or sex abuse charges since July 25th. And when pressed on the policy that dictates that no one in the Montgomery County law enforcement community no one is allowed to communicate with and speak with ICE officials, and certainly they are not allowed to respect or follow an ICE detainer. When challenged on that, County Executive Mark Elrich has said, the Constitution forbids us from doing so. It's unconstitutional to hold someone on an ICE detainer. Is that right? Are we sure about that? Is that what the Constitution says? Dale Wilcox is Executive Director and General Counsel of Immigration Reform Law Institute, and he joins us now. Mr. Wilcox, is that right?
That's absolutely false, Larry. Absolutely false. The Constitution does not prohibit state and local jurisdictions from holding suspected illegal aliens on behalf of ICE.
So where is this confusion? Let's be generous and say that this is confusion, all right? Where is it coming from? Because they're claiming that without a warrant from a judge, you can't unlawfully detain somebody. How does an ICE detainer work outside of that?
Okay, what happens is when an alien or anybody is picked up for committing a crime, their fingerprints are taken. Those fingerprints are sent to the FBI. The FBI shares that with DHS. And DHS will send what's called an ICE detainer request to a local jurisdiction when they have reason to believe that the person's in the country unlawfully. And the detainer request asks the jurisdiction to hold the individual for up to 48 hours once that individual is eligible for release, say on bond or they've served their sentence, so that ICE can come pick them up and institute deportation proceedings, get them out of the country.
Go ahead, keep going.
Well, what the county executive here in Montgomery County is saying is that, it's unconstitutional for us to comply with that detainer request, which is accompanied by an administrative arrest warrant. Now, they're saying an administrative arrest warrant is not enough. You need a judicial arrest warrant from what we call an Article III court or a criminal court. That is not true. That has never been true since the founding of this country. Immigration is a foreign affairs matter. Congress has absolute control over this. They have set the rules, and the executive, DOJ, DHS, has the authority to issue arrest warrants and hold people. And local jurisdictions have the authority, and it is constitutional for them to comply with these requests to hold them. The Fourth Amendment of the United States Constitution only protects you from unreasonable search and seizures. This is not an unreasonable seizure. It's been done since the founding of this country, and and quite frankly, I have to be more cynical than it's confusion or a mistake. He is clearly operating off of Casa de Maryland and the ACLU's talking points. I mean, some of this stuff is word for word.
Yeah.
That's the theory that they've come up with and that they're arguing all around the country to thwart immigration enforcement.
And by the way, these ICE detainers are very important because, let's just be clear here, basically ICE just notifies law enforcement, hey, we'd like you to hold him for 48 hours from when he is released so that we can then talk to him and he can go through immigration proceedings. And again, these are people who have been incarcerated. They've been arrested for crimes. And that's because there is no there's no rule of thumb in terms of the release process, right? I mean, a judge could say, okay, this guy's post his bond, you could release him, and you could have like a 2-hour window and he's on the streets, right? That's why the 48 hours is important.
You're absolutely right. I mean, logistically, it's tough for ICE to get to every location around the country to send personnel to pick them up. ICE doesn't have that kind of personnel, and so they need at least 48 hours notice. These are excuses. This is a political game that they're playing with people's lives. The excuses is just obfuscation. What it comes down to is they're trolling for potential future voters. And I mean, it's sick. It's Montgomery County is the most extreme sanctuary policy I've ever witnessed. They make California look cooperative. California at least will hold someone if they've committed a felony or 3 serious misdemeanors. This executive order, this sanctuary policy in Montgomery County has no exceptions whatsoever. And as you noted, there have been 5 instances here recently in a month's time of rapes allegedly committed by illegal aliens.
Well, and now, and again, they claim, and County Executive Elrich has said now that if it's a serious crime, then they're going to go ahead and communicate with ICE. He hasn't told us exactly what that means, but we assume it means rape and murder. But there's where I'm confused, and that's why I'm glad you're here, because you're a lawyer, Dale Wilcox. If you've got a constitutional right against being held without a warrant, does that right get waived if you happen to be arrested for this crime versus that crime? I mean, the severity of the crime has nothing to do with whether you have a right or not.
You're absolutely right. You've picked up on a fallacy in these arguments that even California, I mean, they're not being true to the Fourth Amendment if indeed that is the case.
Yeah.
But I don't see how they can inform ICE of even serious offenders, because if you look, I have this executive order right in front of me, 7 pages, and it says that county officials are not allowed to use any kind of county resources, monies, facilities, property, equipment, personnel, or other assets funded in whole or in part by Montgomery County to assist in federal immigration enforcement. So how can you pick up a county-owned phone and call ICE to notify them?
Right, you'd be violating that executive order.
Yeah,
that's right.
They're violating their own order, so I don't believe it.
One other question on this, Dale Wilcox, got a minute left. The state's attorney general, Mr. Frosch, has said, well, he said a couple of things. First, he said that it's up to each county via the sheriff or county executive to determine whether they're going to cooperate with ICE. Yet at the same time, he's also said this, and I'll quote, "Local officials may not hold someone beyond their state law release date in the absence of a judicial warrant or probable cause that the subject has committed a crime." And that sounds reasonable, but here's my question. Isn't an ICE detainer more than probable cause? If the federal government says, we have a detainer on this guy, please hold him, I would think that local law enforcement says, okay, there's our probable cause.
Absolutely. In fact, if you look at the actual, anybody can Google the ICE detainer form. If you look at the form itself, it says, we have probable cause to believe the individual, and then you check boxes. Is in the country illegally, has an outstanding order of removal pending, and on and on. So there's what's called in the law the fellow officer rule. Officers of the law can rely on another officer's statement that they have probable cause. We do it all the time in the system. But bottom line here, these politicians are playing games, and they don't want immigration law to be enforced. I mean, this executive order goes so far as to say that you cannot even help investigate criminal violations of immigration law, which means something like appropriating your Social Security number or birth certificate. I mean, that's absurd.
It is absurd. And Dale Wilcox, Executive Director and General Counsel of Immigration Reform Law Institute, thank you for joining us.